This is Lecture 11, Claim Construction 1, Introduction to Claims. The agenda for this lecture is to talk about what claims are, the role that they play in the patent document, patent system altogether, frankly, and then talk about who decides the claim construction issue. This is an important issue, and in fact one that's been recently revisited by the Supreme Court, and so those are the two things we're going to do in this lecture. So first, introduction to claims. So backing up for a minute, we are now sort of entering our second module of the course, that being the enforcement of patents module. What we've done up to this point in the course is talk almost exclusively about the standards for patentability, what types of requirements there are for patentability of an invention in the patent system. All right. As we've talked about before, the standards for patentability, of course, don't end after you receive a patent. You can still challenge a patent for its validity if it's asserted against you. So it certainly isn't the case that validity has no place at all in the enforcement piece. But we are going to turn now for the next several weeks on to look in more detail about how patents are enforced. And our first piece of that really is how claims are dealt with and how we understand claims. Later on in the course, we're going to talk more about the institutional design of the system. But the important thing I want to make, the important point I want to make at this point is to understand, and you probably already realize this from the course so far, is that claim construction is at the core of almost everything we do in the patent system. Right? We absolutely have to have an understanding of what these patent claims mean in order to be able to do almost anything else, whether that's measure validity, determine infringement, determine damages. All of these things require at some level to have a well-defined, hopefully, set of claim instructions. So patent claims are the primary yardstick of patent rights. That's the sort of general rule in the patent system, is that when we talk about what the invention is, when we talk about what's covered by a patent, when we talk about whether a patent is valid or not, what we're talking about are claims. We're talking about the claim language itself. That's what defines what an inventor, what a patentee owns, and what is covered and what is not covered. And so one question that I want you to think about is, why would we do this? Why do we use these claims, which, as you already know, are written in a rather vague but specific sort of language? They have their own special type of syntax, as we'll find out more and more, their own special meanings for different words. Why would we use these as our yardstick of patent rights, right? The specification, the entire disclosure offers a lot more information about the invention, about what it is that the patentee thinks he or she has invented, and what's come before, what are the limits on the invention. And so why not use a disclosure? Why not use the entire description of what the invention is as our yardstick for measurement, rather than these claims, which are subject to a variety, as we've already seen, of possible manipulation, right? And the answer, I think, is that what we want is to have a single place where we force patentees to very directly describe exactly what it is that they have invented, right? And be very clear as we can make them be, about what it is they have invented, and more importantly, perhaps, what they have not invented. And the problem with using sort of the specification as our yardstick for patent rights is that it is by its own purpose intended to be a broad overview of not only the invention, but what came before the invention, the prior art. All of these sorts of things are part of what the specification should provide, and I think that's right. We want the specification to provide as much useful information to society as possible, but at the end of the day, we need a place where we can go and we can see what the patent rights are. Right? We can see that this is indeed what the patents covers and what it doesn't cover. right? And I often like to think about patent claims much the same way that you would think about, for example, a land deed, right? And any of you who've seen a deed will know that it is also written in fairly arcane technical language. It also is not particularly useful in the sense of visualizing what it is the property actually covers, right? It will say things like, from a spot at this latitude and longitude, 200 feet to the northwest, turn right 75 degrees for another 700 feet, etc. Right? Very, very specific language outlining the property itself. Doesn't tell you anything about what's in the property, what the property has, what the value of the property is. Anything like that is not included in those land deeds, and yet we still use the deeds as the yardstick, the primary measurement of what the property is. And I think we want patent claims to be like that. We want them to be our locus of analysis, but we're going to use other things like the specification, the drawings, the written description, the general context, the person of skill in the art to actually understand what an invention is. But the claims at the end of the day are what define the rights. And that's why we need to pay attention to what they mean. The other thing to understand is that patent claims are the one piece of a patent application that you can amend at will during patent prosecution, right? As we've said several times before, you can't add new material to your patent application during prosecution. Well, you can, but you lose your filing date, right? So if you want to keep your filing date, you can't add new material to your patent application. Different with claims. Claims you can change, and in fact, almost all of the activity surrounding patent prosecution involves claims and changing the claims, changing the definitions of the rights granted by the patent, rather than providing less material or different kinds of material information to the patent office. So because of that, that means patentees have this almost limitless ability to use claim language in their own strategic purposes. Now, it's not completely unlimited because, of course, the patent office is going to review those claims for patentability, and later on, of course, claims are reviewed for patentability by the courts. But within that context, the types of choices regarding claim language are generally unfettered, and therefore we often talk about how patentees can, in a sense, manipulate claim language to their advantage. And indeed, I think what you're going to find over the next couple of classes is that most of the law surrounding claim construction is intended to basically prevent that very thing, which is to prevent patentees from essentially taking advantage of the claim construction system by manipulating claims to their advantage in that way. And so that's why it's true that patentees may be able to manipulate patent claim language to their own advantage. We're going to have a variety of tools, doctrinal tools, that are going to try and prevent that, but it is something that we need to keep in mind. Right? So Judge Rich, who is one of the drafters of the Patent Act in 1952, later became the longest-serving federal judge in history, and until his death in 1998, said, to coin a phrase, the name of the game is the claims. Right? The name of the game in patent law really is claims, and understanding claims is critical. So how should we think about patent claims? Right? I mean, one thing is when you're talking about interpretation, we already know how to do interpretation of written documents. We see them before, right? For example, we have statutes, right? As another example, we have contracts, both written documents, textual documents that often need close and careful interpretation to ascertain their meaning. So are claims like these? Are they like statutes? Well, they might be like statutes in the sense that they are enforced against the public. In a sense, a claim is a public right? It's almost, in a sense, a mini statute saying no one can make, use, or sell those subject matters which fall within the scope of these words. Right? On the other hand, you might say claims are a little more like contracts, right? Because in a sense, they are a negotiated deal between the patentee and the patent office, who, of course, the patent office in this context is standing in for the public as the representative of the public at large. And so that's the way that this system works. And so you might view patent claims more like a contract. And I think depending on how you think about statutes or the patent claims and how close they are to sort of the public nature, public statutory nature, or a deal created contract, I think will change the way that you think about the interpretation of claims, right? The other thing to understand is that one of the important tenets of claim analysis is that we allow patentees to be what we say is his or her own lexicographer, right? By that we mean that patentees can assign whatever meaning they want to whatever word they want. Now, why would we do that? Well, part of the challenge here with patent claims is that we are asking patentees to describe concepts, ideas, new innovations in terms of words. And that's a very difficult proposition. It's just inherently difficult. It might be that for certain kinds of inventions and innovations, the words just aren't available, or the ordinary meanings of the words just aren't appropriate given the circumstance. So we give patentees a lot of latitude to sort of craft their own definitions, craft even their own words for describing their inventions. Now, we do require, if you're going to be your own lexicographer, that you as a patentee provide enough definition of what you mean so that a person of ordinary skill in the art can understand what you're doing. But we do allow a lot of latitude. And so this is part of the trade-off of claim language, is we want it to be clear. We want the public to be able to read patent claims and receive notice as to what the patentee owns and does not own. On the other hand, we don't want to hamstring the patentee and make it impossible to actually fully describe the invention by making them not able to use the kind of words that they want. And so that's part of what we are trading off in this area. There's a two-step infringement analysis just to sort of get ahead to our enforcement, right? So everything is, if you're going to determine whether somebody infringes your patent claim, there's a two-step analysis. One, interpret the claim, right? First thing, got to figure out what the claim means. And then second, determine whether all of the elements of the claim are present in the accused device or product or method, depending on the type of claim, right? This is for literal infringement, as we'll find out in a week or two, though there's also the doctrine of equivalence, which is slightly different than this, although still has the basic structure. The idea, again, here is that you first interpret the claim, and then you, using what you now know to be the claim meaning, you determine whether all of those elements are present. Very similar for a two-step validity analysis, right? Your first step is to interpret what the claim is. And the second step is to determine whether it meets the standards that we've already gone through, the Section 112 standards for disclosure, the Section 102 standards for novelty, and the Section 103 standards for non-obviousness. And again, you will note that the key here is that you have to interpret the claim first to get at any of these things, right? And so it's both important for infringement and validity, in fact, central. In fact, not even central, it's the first step. You can't even do infringement or validity without having an analysis of the claim and understanding of the claim first. So how do you write claims? Well, we're going to do this in class together. Using at least at first a stool here to try and sort through some of the issues surrounding how to write a good patent claim. In some detail. So something to think about is that how would you describe this image, this picture, this structure in claim language? How would you claim it as a patentee? And remember the strategic trade-offs that we talk about, right? Which is you are trying to both get as much subject matter coverage as possible. Why? Well, because that's going to maximize your value, maximize your protection in the marketplace. And at the same time, you're trying to make sure you don't encompass any of the prior art or render yourself obvious in light of pieces of the prior art. So you don't want to claim too broadly, and also you don't want to claim so broadly that you can't fully disclose your invention either. So you've got a number of important trade-offs to weigh against each other as you're drafting claim language. So even a simple exercise like a stool can often be a challenge in terms of figuring out how to draft the claim. Okay, so what does claim construction look like? Right? So for this, I want to just give you a quick overview by looking at the Markman patent that I had you read the Markman case, the classic case on claim construction at the Supreme Court in 1997. And so this is about inventory, right, for a dry cleaning system. And here's claim 1, the inventory control and reporting system comprising, and I've underlined each of the major elements of the claim: a data input device, a data processor, a dot matrix printer, and at least one optical scanner, whereby said system can detect and localize spurious additions to inventory as well as spurious deletions therefrom. Right? These are what we call limitations of the claim. The underlying pieces are major limitations of the claim. The rest of the text is sort of additional limitations. Something to think about is essentially every word you put in the claim limits it to some degree, but some words limit it more than the other. And the way that I like to think about claims is to try and break them down into their major limitations, right? And here, sometimes the patentees will help you by actually putting carriage returns or new lines after what they consider to be the major limitations, although that's certainly not binding. But here you can see what has been done is that you have different clauses. You have a data processor clause, which includes memory, a dot matrix printer, operable under control of the data processor, an optical scanner connected to the data processor, and then a whereby clause which describes how all of these earlier pieces fit together. Right? And so this is the way to sort of schematically break apart a claim into its pieces, into its constituent pieces. And then from there, once you've broken this big problem apart, you can start to dive in and try and interpret the various pieces of the claim. Now, as a practical matter, in almost all cases that we're going to read and that come to litigation, there's going to be a dispute typically about a small number of the important claim elements or limitations. And in the Markman case itself, the word inventory was the sole point of contention. What do we mean by the word inventory in Claim 1 of this patent is what sent this case all the way to the Supreme Court. And you'll see inventory appears in a variety of places in the patent, or in Claim 1, related to the data processor and the whereby clause in particular. And the dispute here was, what does inventory mean? Account receivables? Does it mean clothing? Because this, again, was in the context of a dry cleaning system. Or does it mean both, right? And why does this matter? Well, the Westview system tracks only the receivables rather than the clothing, right? So the system, the computer system that was being used by the accused infringer was tracking receivables, okay? And so inventory, according to the patentee, could include receivables, right? And what happened here was a jury found that this did infringe, right? But the district court in the Markman case entered a judgment as a matter of law, reversing the jury, saying that the word inventory required the system to track both clothing and the receivables associated with that clothing, meaning the money that was owed, right? And so because the Westview system only tracked money that was owed, the accounts receivable, it was not found to infringe, right? And so that's why the court, why ultimately Westview was found to not infringe. Markman appeals, saying that the claim construction was incorrect, and more importantly, that the claim construction was done by the wrong party, done by the jury rather than the judge, and that's what sends the case to the Supreme Court. right? How do we know, right? How do you figure out whether inventory means both, right? So one thing you can do is you can look at the claim itself, right? And try and figure out here what it says. Well, what does inventory tell us here? Well, we can say it says inventory total, and then we can see it says additions and deletions. So hard to tell from the claim itself. What about the description, right? And so you can read this paragraph here, paragraph 5 that I've put in, and try and determine from this context whether or not this is something that is going to encompass receivables only, both, or just clothing. And that's sort of the trick. And so, and the interesting thing is you can get more information, of course, if you go into the specification, right, and read the detailed description. On the other hand, the specification is not the claim, right? And so it's a tricky question as to how much you should take from the detailed description of the preferred embodiments, because although it might describe the invention in some ways, it's not the claim. And one of the core issues about claim construction is how much information, how much context should we draw from the detailed description of the preferred embodiments. And that is something that we're going to talk about mainly in class 14, but we're going to touch upon it a little. And the primary case I want to talk about here today is Markman versus Westview, which is the Supreme Court's case on claim construction, 1996. As I introduced a minute ago, the dispute in Markman surrounded what the term inventory means, what the patent claim term inventory meant. Did it include accounts receivable or simply clothing or both? And so that was the central dispute of the case. But what makes it to the Supreme Court is the question of who gets to decide that question, right? Is that a jury question or a question for the judge? And sort of in the terms that we use in law for understanding that, is it a fact question, and thereby meaning that it goes to the jury and the jury can weigh that like all other facts? Or is it a law question, in which case it goes to the judge and the judge gets to determine it as well? Right? And so this is the question that the Supreme Court takes up in Markman. Is claim construction a question for the jury or for the judge? So the opinion was written by Justice Souter, and like many Justice Souter opinions, it's pretty much difficult to understand exactly what he was saying at various points. But one thing that he does start out by saying is he describes claim construction as a mongrel practice, like construing a term of art following the receipt of evidence, right? So what does this indicate? Well, this indicates that right from the outset, the Supreme Court was thinking of claim construction as neither a pure question of fact nor a pure question of law. That instead, what the Supreme Court was thinking of is it was somewhere in between. It was this sort of mixed creature, or as Justice Souter says, a mongrel that fits somewhere between the two concepts of fact versus law. So that's extremely unhelpful, right? Here's our long-suffering district court judge saying, all we want to know is, what am I supposed to do? Am I supposed to give this to the jury? Am I supposed to give this to the judge? Or am I supposed to keep it myself, or what? And so how do we decide that? Well, there's a traditional analysis. I mean, the way that this dispute is couched is whether there's a Seventh Amendment right. Seventh Amendment, of course, as you'll recall, gives litigants the right to a jury trial. And so there's the traditional analysis of Seventh Amendment rights, judge-jury issues. And what the Supreme Court says is there's basically three ways to go through this. First, you look at the Seventh Amendment guarantee, right? And the Seventh Amendment guarantee has a particular kind of analysis, that being you would look at the time of the drafting of the Constitution and try and discern whether or not a particular issue was given to juries or given to judges, and that would control, right? Because the way that the Seventh Amendment right is construed is that it was supposed to essentially freeze in place the traditions as of the time of the writing of the Constitution. And the second point, if that doesn't solve the question, is to ask, is there some sort of precedent? Has precedent over the years of common law development emerged that would lead one to allocate the responsibility to the judge or to the jury? And then third, if both of those two analyses don't lead to a decision, then you can ask, finally, are there functional reasons, right? Are there good reasons other than precedent or the Seventh Amendment guarantee to allocate this in a particular way? And so this is the way that the court works through this, right? And it finds that as of the time of the drafting of the Constitution, there really is no conclusive evidence surrounding whether or not a jury trial was guaranteed for claim construction. They find examples both in the U.S. and England of cases where juries have decided patent claims and judges have decided patent claims. And in part, this is because the concept of patent claims didn't really emerge until much later, more like in the 1830s and 1840s. So it's not surprising that they didn't find any good information about the right as of the signing of the Constitution. So the second point, does precedent command the allocation of responsibility? And the court surveys precedent from the time of the founding to date and essentially determines that there is no clear precedent requiring that either the judge or the jury be given the task of construing patent claims. And so therefore it moves on to prong 3 of the analysis and says, are there functional reasons to allocate the responsibility? And from there, that's where this gets pretty interesting, right? So the court describes its functional analysis in this way. The construction of a written instrument is one of those things that judges often do and are likely to do better than jurors, unburdened by training and exegesis. Patent construction in particular is a special occupation requiring, like all others, special training and practice. The judge, from his training and discipline, is more likely to give a proper interpretation of such instruments than a jury, and he's therefore more likely to be right in performing such a duty than a jury can be expected to be. Right? So there's point number 1 in a functional analysis, that judges are, by virtue primarily of their legal training, their legal experience, are simply better at construing written documents, and that is a functional reason to allocate this towards the judge. Right? Now, the one response is that, these are written documents. Patents are written documents. Claims are, of course, written documents, but these are not written in traditional legal language. So it's not like statutory language or even contract language where a judge would understand by virtue of training how to interpret them. In fact, these are descriptions of concepts and ideas and often very high technology that the judges would naturally have no particular background for. So the response to that is why would judges in this context be any better than a jury given the benefit of expert witnesses, right? And the argument would go, judges are going to need to be taught about the technology anyway in order to make an informed decision. And if once you go down the road of having to teach somebody, why not just teach a jury, right? Why do you think a judge would do better in that context, right? And Souter responds to some of these concerns by saying, we expect credibility determinations will be subsumed within the necessarily sophisticated analysis of the whole document required by the standard construction rule that a term can be defined only in the way that comports with the instrument as a whole. Thus, in these cases, a jury's capabilities to evaluate demeanor, to sense the mainsprings of human conduct, or reflect community standards are much less significant than a trained ability to evaluate the testimony in relation to the overall structure of the patent. Right? So again, this idea that although, yes, there might be testimony required to understand the technology, and that we generally think when we're taking testimony that juries are going to be better at evaluating competing testimony than judges. That's a traditional thought in American law. Here, Souter says that we think that in fact judges are still likely to be better because they're going to be more sophisticated at understanding how any expert testimony fits into the overall document structure, and to understand while interpreting and while listening to testimony that you still have to use the basic rules of construction of written documents, right? And then this is an interesting point, and this, I think, becomes a important and perhaps the key point in favor of what the court does here, which is they say, finally, this is after describing why judges seem better than juries at doing this, finally, we see the importance of uniformity in the treatment of a given patent as an independent reason to allocate all issues of construction to the court. It was just for the sake of such desirable uniformity that Congress created the Court of Appeals for the Federal Circuit as an exclusive appellate court for patent cases, observing that increased uniformity would strengthen the U.S. patent system in such a way as to foster technological growth and industrial innovation. Right? So one thing is, so this is a uniformity mandate, right? So what the court is saying here, what Justice Souter is really saying here, is that independent of the fact that they think that judges might indeed be better at construing patents, they actually think that there's a uniformity reason. Now note that here, the uniformity in the treatment of given patent, now that isn't necessarily a particularly strong or compelling argument because of issues of collateral estoppel, issue preclusion, which would allow, in general, for a court decision on a particular patent to also be binding on later courts, right? But the court continues, Justice Souter continues to say, uniformity would be ill-served by submitting issues of document construction to juries. Making them jury issues would not, be sure, necessarily leave evidentiary questions of meaning wide open in every new court in which a patent might be litigated, for principles of issue preclusion would ordinarily foster uniformity, citing Blonder Tongue, right? So making the point I just made, which is you wouldn't really need this uniformity concept because of the Blonder Tongue line of cases, which says that there's issue preclusion. So once an issue was decided related to a particular patent, that would then have been decided at least as against the patentee. But whereas issue preclusion could not be asserted against new and independent infringement defendants, even within a given jurisdiction, treating interpreted issues as purely legal will not guarantee intra-jurisdictional certainty through the application of stare decisis on those questions not yet subject to intra-jurisdictional uniformity on the authority of a single appeals court. All right, that's a long sentence. Let's unpack it. Right? What the court is saying here, I think, right, is that although they agree that issue preclusion would deal with the same patent, same question issue, right, there are still uniformity reasons to send claim construction to judges. And that is because the application of stare decisis, like cases should be decided in the same way, could be used to promote uniformity, right? Intra-jurisdictional uniformity. What do they mean by that? Well, here's what I think they mean. What they mean is if we allow the U.S. Court of Appeals for the Federal Circuit to decide cases as a matter of law relating to claim construction, then what that court will do is create a set of rules, a structure, a framework, a mechanism for claim construction that will then be binding on district courts throughout the country, right? And indeed on the Federal Circuit itself, and therefore promote uniformity, not because the same patents are being litigated over and over again, but because the same rules will have to be used in each given case. And the concern that the court seems to have with sending patent claim construction to juries is that because you can't really review the way that the jury decided, you can only review their decision making. Because you can't review the way they decided, you can't have this type of uniformity. You can't develop a set of rules, a set of tools, a mechanism, a framework for claim construction like you could if it was an issue of law that goes to the Federal Circuit. And therefore, the court says in Markman that claim construction is for the judge, right? So I think this is important. And the important thing is that what it says is that there's a mandate, right? There's a mandate for the Federal Circuit to create exactly what the Supreme Court suggests it should, which is a set of rules, a structure, a framework for claim construction that will promote intrajurisdictional uniformity under its authority. So the implication of Markman is that judges should be doing claim construction because the Court of Appeals to the Federal Circuit are going to create a uniform system of claim construction rules. Conversely, what that means is if the Court of Appeals to the Federal Circuit doesn't create, can't create, fails to create a uniform system for claim construction, then a lot of the reason that we would allow judges to interpret claims is undermined. There's still the piece in Markman about judges being just simply better at construing written documents than juries, but the court seems to rest a lot of weight on the uniformity principle and indeed what I would describe as a uniformity mandate. Right? So this implies a really significant role for the Federal Circuit in claim construction. Not only that they get to review all the cases and review all the cases de novo, but that they have a mandate to create this structure, this framework, this mechanism. And so one of the questions going forward that I'll ask you about in particular next class is whether you think the court has done that and whether you think that's been a successful experiment since 1996. So a final note here is the Cyborg case, which follows up on Markman a couple years later. So one of the issues that was left open by Markman was, okay, so if it's a judge decision, but yet the court describes it as a mongrel practice, doesn't really say whether it's a fact decision or a law decision, how much deference should be given to the district courts in terms of their decision making, right? So those of you who will remember back to civil procedure, if a district court decides a case on a factual basis, then that is reviewed for clear error by the appellate court. If instead the district court decides a case using for legal principles, then those legal principles are reviewed de novo by the appellate court. Right? So that's the difference, the level of deference. You give more deference to the fact finding by the district court than you do to legal conclusions of the district court. And that's what Cyborg was about, right? Cyborg is about the question of, even if the judge does it, how much deference should the Federal Circuit be giving to district court analysis of claim construction, right? And so Cyborg is an en banc case. One of the things that had happened in between Markman and Cyborg is that different panels of the Federal Circuit had interpreted the role of deference slightly differently, and Cyborg took the case en banc, meaning the entire court sat as a whole to try and resolve it. Right? And so the court says this: the opinions in some of our cases suggesting that should be deference to what are asserted to be factual underpinnings of claim construction assert support from the language in Markman 2 stating that construing a term of art after receipt of evidence is a mongrel practice, and that the issue may fall somewhere between a pristine legal standard and a simple historical fact. These characterizations, however, are only prefatory comments demonstrating the Supreme Court's recognition that the determination of whether patent claim construction is a question of law or fact is not simple or clear-cut. They do not support the view that the court held that while the construction is a legal question for the judge, there may also be underlying fact questions. So one question is this a fair characterization? Right? You might argue that this is not really what the court meant. Are these merely prefatory comments showing that the Supreme Court recognized the complexity? Or instead, is it what they are saying, what the court was saying in Markman, is that this is indeed somewhere between law and fact and that they don't regard it as clear-cut? Right? And so that's an open question. But what the court then goes on to say is, indeed, the uniformity passage, the stuff we talked about a minute ago with respect to uniformity, demonstrates that the Supreme Court endorsed this court's role in providing national uniformity of the construction of the patent claim, a role that would be impeded if we were bound to give deference to a trial judge's asserted factual determinations incident to claim construction. All right? So that's really key, right? Which is they then, in Cybor, the Federal Circuit says the way that we can implement our mandate, the mandate of uniformity, intra-jurisdictional uniformity given to us by Markman, is that we need to have de novo review of claim construction. Because if we had to give deference to district court judges, then we wouldn't be able to create as well a set of rules for claim construction. And I think they're probably right. I think the best way, if you want to create a rule-like structure, a set of legal principles, the best way to implement that from the appellate court level is to have de novo review of the decisions that go below, because it allows you in every case to reconsider what the district court did and provide maximum amount of guidance and rulemaking with respect to the framework that you want to achieve. And so I think the Federal Circuit, although I think they were probably unfair in characterizing some of what Markman said, was correct in Cybor that if the goal is for uniformity, if the goal is to build a set of rules and tools surrounding claim construction, then the right way to do that is to have de novo review. Now, what that also may mean is that if they aren't going to do that, if they aren't going to have clear rules, uniform principles that the district courts can apply, then it is not then the reason for de novo review falls away fairly quickly. And so that, again, something to think about as we go forward. So finally, just to finish up here, the Phillips case, which we're primarily going to study in Class 14, revisited as part of the questions the court said it wanted to have answered en banc, revisited the question of deference and says, and ducked it, right? Basically, the court announced that it was going to reconsider Cybor in Phillips, and then when it actually wrote the Phillips opinion, it said it declined to reconsider Phillips. And indeed, ever since Phillips, there's been an ongoing sort of simmering dispute at the Federal Circuit about the Cybor issue, whether there should be deference or not. We'll talk about that some more in the next class. But this just a flag for you that this is an ongoing issue. And in fact, in Phillips, Judge Mayer had a vigorous dissent. Judge Mayer says, I am convinced of the futility, indeed the absurdity of this court's persistence in adhering to the falsehood that claim construction is a matter of law devoid of factual component. Because any attempt to fashion a coherent standard on this regime is pointless, as illustrated by our many failed attempts to do so, I dissent. While this court treats the district court as an intake clerk whose only role is to collect, shuffle, and collate evidence, right? The reality, as revealed by conventional practice, is far different. If we persist in deciding the subsidiary factual components of claim construction without deference, there is no reason why litigants should be required to parade their evidence before the district courts or for district courts to waste time and resources evaluating such evidence. Instead, all patent cases could be filed in this court. We would determine whether claim construction is necessary, and if so, the meaning of the claims. Those few cases in which claim construction is not dispositive can be remanded to the district court for trial. In this way, we'd at least eliminate the time and expense of the charade currently played out before the district court. Eloquent words can mask much mischief. The court's opinion today is akin to rearranging the deck chairs on the Titanic. The orchestra is playing as if nothing is amiss, but the ship is still heading for Davy Jones' locker. And that's quite a dissent by Judge Mayer. And he points out that the natural effect of the Cybor rule is that unless, and in his view, the Federal Circuit has not done this, but unless the court creates a set of coherent rules and legal standards, then no case, no patent case will ever be final until it is appealed to the Federal Circuit. Because the de novo review of claim construction, which is such an important component of every single patent case, is almost certainly going to be dispositive of whatever issues are in any particular case. And because of that, you won't know whether your case is done. And you won't have any certainty more than a coin toss as to whether your case is finished until you appeal it to the Federal Circuit. And in Judge Mayer's view, and frankly in the view of a lot of people, that's an unfortunate situation. and that Judge Mayer says we should just go ahead and file cases at the Federal Circuit and let us decide it first. You might imagine that district courts are very upset by the CYBOR standard. They have rebelled in a number of ways, made nasty speeches, criticized the court in various ways. A lot of what you might expect is happening is that district courts are very quick to grant summary judgment in patent cases. This is not because I think they really legitimately believe that summary judgment is warranted in every patent case, but the one virtue of summary judgment from a district court perspective is it doesn't waste the time of a trial. It gets the case finished and up to the Federal Circuit, whereby the Federal Circuit can evaluate the claim construction. And then if it gets reversed, you haven't lost an entire trial. If it is reversed, then the court can go ahead with trial on the claim construction given by the Federal Circuit and onward. And so that might be a way that district courts are responding to this issue. There have been a number of proposals for interlocutory appeals for claim construction. Interlocutory appeals are a process whereby you can certify particular questions of law to an appellate court before final judgment at a district court. So far, the Federal Circuit has not been particularly amenable to those, although I think that might be changing now. But in general, this has been an issue. This CYBOR no deference issue has been one of great dispute at the court, and really, as I said before, depends almost entirely on its justification for the idea that the Federal Circuit is going to develop a set of rules and tools, a framework, a mechanism for district courts and others to understand how to interpret patent claims. So that's lecture 11 on Introduction to Claims, and in particular, who decides claim construction. I should note that as of early 2015, the Supreme Court issued the Teva versus Sandoz case, and that case changed the parameters to some degree of who decides claim construction. It also probably modified the way that claims are going to be interpreted. So look for a additional lecture, short lecture on that case in particular to talk about how it affects the current case law that we just discussed in this lecture.